Welcome to the Supreme Court of the United Kingdom, where we are continuing to hear the appeal in the case of SC and others and the Secretary of State for Work and Pensions, concerned with the two-child limit on child tax credit. We are now turning to counsel for the Secretary of State, Sir James Eadie. Sir James.
My lords, my lady, just by way of the briefest introduction, this challenge, as you know, is to new primary legislative provisions that apply only to children born to a responsible person after the 6th of April 2017. And they have the effect of removing the individual element of CTC in respect of a child, unless in effect there are only two children within the household for whom the individual element is claimed, or an exception applies. And the exceptions were created and set out in regulations made for that purpose. And they include a variety of things that don't need to concern the court for the purpose of this challenge. The point I wanted to emphasize, just by way of introduction, is that there was, as a result of this legislation, no change whatever to other existing entitlements. And that's a position that's made clear in Mr. Higlett's statement, which you find in electronic bundle 563 in the appendix if you're operating on hard copy, part 2, hard copy 365, but electronic 563 is where Mr. Higlett's statement starts. I'm not going to spend long on it because I don't think there's any great dispute about this, but it's at least worth bearing in mind. The housing benefit regime, take that benefit, payable to families as it were, was altered, but that was done simply to ensure that the effect of the changes that had been made by the two-child rule was not undermined by the back door. And the effect is simply that housing benefit will not automatically increase so as to negate the effect of the legislation. You see that from Higlett paragraph 15 on page 567. And housing benefit can involve, as you know, payment of 100% of the rent that a household is required to pay. And it will continue to pay 100% of the rent that a household is required to pay if you are entitled otherwise to housing benefit, even if you have to move to a larger property as a result of a third or fourth child. That's also Higlett paragraph 15. Child benefit is then dealt with in Mr. Higlett's statement at paragraph 16 on page 568, and that continues to be payable for any number of children as before. See Higlett 16 and Higlett 72 Roman 1. And you'll note the subtleties already built into that regime. There's no uniform increase in costs for each child. The greatest increase, as Mr. Higlett points out at paragraph 79, page 585, is child 1, as reflected in the fact that child benefit is paid at the higher rate for child. So that's child benefit. Childcare costs elements of working tax credits and universal credit dealt with in Mr. Higlett's statement at paragraph 16 and 72 again. They remain the same. But so too do other types of support available to families with more than two children. And Mr. Higlett at paragraph 72 lists all the other support available to families with children. And paragraph 73 of that statement sets out the government view that this amounts to reasonable assistance to the cost of caring for children. It might be worth noting, if you're there, paragraphs 78 and 79, refuting in summary the subsistence point. And that's in 78, and in 79 making the point that adding an additional child to a family does not increase costs in a uniform way. So the upshot of all of that is that this is an adjustment to a scheme, varied and multifaceted as it is, of social security benefits. And there is, of course, the overall balance to be struck between the proper payment that is to be made to those on state benefits and the proper management of public money. That's all I wanted to say about the regime. The rest is clearly, and I think uncontroversially, set out in the judgments both of Mr. Justice Ouseley and of the Court of Appeal. So far as the facts of these individual cases are concerned, I don't know if you have the Court of Appeal's judgment to hand. I'm going to try and do quite a lot of these submissions by reference to paragraphs in that. So if you have it loose, the facts of these cases are set out in paragraphs 13 and 14 of the judgment of the Court of Appeal. And the position in relation to these claimants, at least, I fully appreciate this is a challenge to the legislation and the legislative scheme as a whole. But so far as these claimants are concerned, they are not at all below subsistence. They no doubt face hard choices, as do many others. They are all, or were at the time they made the statements, all managing to make ends meet and budgeting. And the fact is, therefore, that the breaches of their human rights that are alleged in this case involve a recalibration of state-funded benefits, which leaves these claimants in a position in which, although no doubt money is tight, they are financially managing and are financially afloat. So that's the facts of the individual cases. My lords, my lady, I was proposing to move straight and immediately to justification. I'm well aware that there are issues that relate to status. I hesitate to enter the arena again with Lady Black on status. She'll have heard most of the submissions I've made on that already, I suspect, so I'll take them quickly. You've equally probably heard from me before on a number of occasions, submissions in relation to ambit and how all of that works. But what I'm going to do, if I may, is to come to those discrete points, i.e. the short points on which we respectfully disagree or offer an alternative view to the view of the Court of Appeal at the end, if I may, not least because in relation to most of those concepts, status, ambit, analogous situation, very often in these sorts of cases, it ultimately is a question of how you characterize things, at what level of generality you start characterizing things. And we do respectfully and as an overarching point before turning to justification, recommend the reality and good sense perhaps of the approach of the Court of Appeal, which was to recognize that in this situation, what one is truly doing is to focus on, and what one should truly be doing is to focus on households and to focus on overall amounts ultimately of social security benefit payable to households. True it is that the mechanism here is the two-child mechanism, but ultimately that is what Parliament was no doubt considering, and that is ultimately the real focus of what is going on here. But with that teaser, if I may, can I turn straight to justification? And I do so because we have now got a 7-judge court. And I suspect that the reason we've got a 7-judge court is because the invitation has been maintained by Mr. Drabble for all the forensic lightness of touch which he brought to that issue. The submission has been maintained that this court should follow the approach of the Strasbourg Chamber or section in JDA. And that, you will not be surprised to hear me say, is an issue of the greatest importance to government, because the correct approach in these sorts of cases, perhaps discrimination and otherwise, is fundamentally affected by that. That no doubt explains why in the Carmichael and MA case, the Supreme Court also constituted itself as a 7-judge court for the purpose of determining precisely the issue as to whether or not MWRF, if I can go to the ghastly shorthand, MWRF was indeed the right case, the right test to apply in the context of discrimination that had been said to occur on a suspect ground. So I make no apologies for taking this issue first and for taking it perhaps rather more fully than Mr. Drabble did, because we respectfully submit that that is a thoroughly important issue, and there isn't a cigarette paper between that and some lesser approach, as it were, that involves recognizing various things and then saying, well, it all amounts to the same thing in the end. It plainly doesn't. So to turn to justification and to that issue, if I may, and just to draw the court's attention to the some key features of the context which you are considering in relation to this appeal. We are dealing with state benefits. We are dealing with decisions of a socio-economic nature on a major scale economically. You've seen the estimates of cost savings over a period of time of £2 billion or thereabouts. We are dealing with a context in which the decisions in question are shot through, we submit, with legislative judgments, involving judgments about how to distribute state funds, about social policies incentivizing work. What the European Court described in its Grand Chamber in the Steck case as the legislature's policy choices. And under our own domestic scheme, you will be very well aware, and don't need me to remind you, of the analogy that exists in relation to this set of issues under the proportionality analysis and the set of issues that arise about the appropriateness of which pillar of the state domestically should have the lead on those judgments. The analogy that can be made with the division between, on the one hand, Section 3 of the HRA, and on the other hand, Section 4 of the HRA. Can you interpret your way out of an incompatibility, or are you thrown into a declaration of incompatibility under Section 4? Again, that set of issues is dictated by similar constitutional drivers to the issues that I will confront. So those are the contextual features of the context. We're dealing with primary legislation. We're dealing with primary legislation passed after there had been all the usual processes within Parliament and a series of debates in Parliament at various stages, preceded by consultation, post-dated by the Social Security Advisory Committee involvement in the fashioning of the exceptions under the regulations. But the debates in Parliament on the primary are summarised. I'll come back to these because they obviously bear on UNCRC paragraph or Article 3.1 and so on, and indeed the Article 9 issues, which I'll come to in a short while. But if you want a factual summary of the debates in Parliament, can I recommend three sources? Mr. Higlet, Section C, paragraphs 24 to 41. '24 is on page 570. The early part of Mr. Justice Ousley's judgment, which you have in the first part of the appendix, where he sets out perhaps rather more fully than Lord Justice Leggett did in his judgment, the various debates and materials placed before Parliament. And I know that you've now had our overnight efforts to try and pull some of the highlights together in the table document that we prepared overnight in response to the invitation from the court to assist on that point. But so you've had a considered piece of primary legislation. And we also note, finally, it isn't mercifully one of those cases where much, if any, reliance needs to be placed on this. But in a context such as this, as indeed in all social security legislation, the drawing of lines, bright or otherwise, is both inevitable and permissible. But it does to some extent go to my categorization point, and it all depends on what level of generality you define the categories at. Ultimately, social security legislation is almost inevitably defining people who do or don't in large groups, do or don't fall within the benefit of a particular provision. And most of the provisions of social security benefits sit alongside each other. We thoroughly agree with Mr. Drabble on that. And it might be thought, therefore, that the appropriate way of really truly viewing this is the way the Court of Appeal did which is to view it principally and realistically through the total amount of social security benefit made available to individual families. So those are the features of the context I wanted to analyse. Can I turn then to the principled approach to justification? And I start as ever with the margin, using that word deliberately to reflect the Strasbourg jurisprudence first up. And the short point in relation to margin is that in this court, the principles that are applicable in a context such as this have been examined and re-examined and examined again. And a clear and principled position has now been reached. That position started from the European Court of Human Rights position and was informed by it. However, as Lord Hoffman famously noted in the Begum case, and I can take it from the Court of Appeal's judgment at paragraph 86, if you have that to hand, in applying convention rights which have been reproduced as part of domestic law by the HRA, the concept of the margin of appreciation has, as such, no application. It's for the courts of the United Kingdom to decide how the area of judgment allowed by that margin should be distributed between the legislative, executive, and judicial branches of government. And that was, of course, a theme picked up by the Supreme Court in the G adoption case, which again you will all be very familiar with. I don't invite you to go to it now, but just for your note, the reference to that is in Bundle 1, Tab 6, starting at page 1153. The margin of appreciation is thus, in Strasbourg parlance, about the respect accorded to the judgments of the national authorities, having regard to their closeness to and expertise in local conditions and issues, and also having regard, a point I recalled overnight was reflected in a case which isn't in the bundles, but with which some of you at least will be very, very familiar, Hatton and the United Kingdom, about aircraft noise, famous principally for the fact that the Department of Transport had brought the night noise over Heathrow down. Principally, it appeared on detailed analysis by redefining the concept of night. But that contained a recognition by the Grand Chamber that democratic legitimacy also fed into the margin. So you have that in the Strasbourg jurisprudence also. But the settlement under the HRA requires a domestic constitutional focus, as those cases that I've cited already, Begum and G, make clear. And we make, in relation to margin, 5 short submissions. The first is that there are compelling reasons for according what the judgment described at paragraph 87 as the full area of judgment allowed to the UK in matters of social and economic policy to the legislature. And the reasons are for that. Those compelling reasons are then set out in the remainder of paragraph 87. Can I just invite you to remind yourselves of that paragraph and that reasoning? All of that will be very familiar, and it'll be very familiar because it directly reflects the detailed analysis conducted by, in particular, if I may say so, Lord Reid and Lord Sumption in Bank Mellat, and again in Lord Carlisle, about the principal basis on which margin sits. Essentially, although Professor Jowl would quibble at the phrase, institutional competence and democratic accountability. And those are keystone domestic constitutional principles. And the breadth of that area of judgment finds expression in the manifestly without reasonable foundation test. And so, as Lord Hodge put it in the DA case, at paragraph 125 on page 1295 in the electronic. 1295, Lord Hodgin, DA. And the passage I really want, or the sentence I really want for this purpose, is the one at the top of page 1295. It is open to a domestic court to adopt that test in relation to socio-economic policy decisions of the executive. We would interpose a fortiori of the legislature in recognition of the institutional constraints on and the constitutional role of the judiciary. And it's been applied, the test, many times since, both in and where appropriate outside. I say where appropriate because those features of institutional competence and democratic accountability may play outside the social security sphere. And there have been cases, one of which I'll come to in a second, the JCWI case in the Court of Appeal, in which the argument was actively mounted to the effect that the MWRF principle or approach only applied in the context of social security. Of course, we are here in that territory, but it's been applied many times since, both in and where appropriate outside the socio-economic judgments inherent in deciding how to structure social security legislation. And indeed, when dealing with legislation reflecting general policy. And you see that latter point about legislation reflecting general policy, in particular in the quote from Lord Sumption in Bank Mellat, set out in paragraph 92 of the Court of Appeal's judgment, when a statutory instrument has been reviewed by Parliament, respect for Parliament's constitutional function calls for considerable caution, and so on. So that's the first principle. There are compelling reasons for recording the full area of judgment in a context such as this. The second point, or the second submission, is that applied when considering whether interferences with substantive qualified rights are justified, this test works, and it's applied equally when considering whether differences of treatment to which that legislation may give rise, and will in our sort of context almost inevitably give rise, are justified. In other words, it applies just as much in relation to a justification under Article 8, simpliciter, and Article 8 when read with Article 14. And MWRF has survived repeated attacks on it in the context of discrimination challenges in the social security context, including, as I mentioned earlier, the full-scale attack on that test that was mounted in the M.A. Carmichael case. And it has been rejected, that sort of attack, in a succession of Supreme Court authorities, including on any number of occasions, 7-person courts. The third point is this. There was some suggestion in the Welsh asbestos case by Lord Mance that the MWRF approach only applied to some elements of the analysis, i.e. the 4-stage proportionality analysis, but not to the 4th stage, not to the final balancing stage. And again, that issue has now been put to bed in the DA case, where that was the prime argument, it appears, and it was rejected as a correct approach, despite being floated at an early stage, I think was the way Lord Wilson put it in relation to the Lord Mance suggestion in the Welsh asbestosis case. But it's now been put to bed in DA, where it was rejected by the majority of 5 on that point. Just to trace a couple of cases in the sequence, if I may, to make good particularly those second and third points. if you start with Humphreys, that is in Bundle 1, Tab 5, starting at 11, passage we want starts at 1144. And this is the judgment of Baroness Hale in the Supreme Court. You'll see the context and the reference to Steck in paragraph 15 on page 1144. And you'll see the nature of the issue from that paragraph. She then cites paragraph 52 of the Grand Chamber's judgment in Steck in paragraph 16, and traces back the concept of MWRF all the way back to James and the United Kingdom in paragraph 17. And she notes in the second sentence of paragraph 17 that in the Steck case, the court clearly applied this test for the state's decisions as to when and how to correct the inequality in state pension ages, which had originally been introduced to correct disadvantaged position of women and so on. And then refers to the Carson case, discrimination on the grounds of residence in relation to uprating of benefits, as you will recall, recognises that the same test has then been taken into our domestic case law and applied in the RJM case, paragraph 18, again in Carson, paragraph 19. And paragraph 19 is of some interest. If I pick it up at the very bottom of the page, after the reference to Carson, which he describes correctly as discrimination on grounds such as place of residence and age, and therefore not a suspect category. And then she says this at the bottom, very bottom of 1145 in paragraph 19. But that was before the Grand Chamber's decision in the Steck case. It seems clear from Steck, however, that the normally strict test for justification of sex discrimination in the enjoyment of the convention rights gives way, that's the phrase, gives way to the manifestly without reasonable foundation test in the context of state benefits. But the same principles are applied to the sex discrimination involved in denying widows' pensions in Runke. If they apply to the direct sex discrimination involved in Steck and Runke, they must, as the Court of Appeal observed at paragraph 50, apply a fortiori to the indirect sex discrimination with which we are concerned. So that's the analysis of Baroness Hale in Humphreys. We then go forward to M.A. Carmichael. That is behind tab 10, and it starts on page 1315. And the key passage is in the judgment of Lord Toulson, and it is between paragraphs 28 and 38, starting on 1327 electronically. And you will see from paragraph 28 that the primary contention of the claimants in MA is that the Divisional Court and the Court of Appeal applied the wrong test in asking themselves whether the discriminatory treatment about which the claimants complained was manifestly without reasonable foundation. I should have drawn attention to the fact that this was also a 7-judge court. One sees from the composition at 1315. But there's then an analysis of whether that's right or wrong, whether something should give way when you're dealing with what might be characterized as a suspect ground of discrimination. There's a citation of exactly the passage I've just taken you through in Humphreys at paragraph 29 on page 1328 to 1329. And then you'll see the analysis, and perhaps the key paragraphs for present purposes are paragraph 32 on page 1330, setting out the principal basis for having that as the test. And then the explanation for what might seem to be a slightly different line of authority or a slightly different emphasis in paragraph 37, the paragraph to which my learned friend drew attention this morning, Andrew Javer and Latvia, but you see the explanation for that is given for that line of cases in paragraph 37. Anyway, it might be thought that that was enough, but the debate continued to rage, if I can put it that way, and back it came in both its guises, i.e. MWRF, the right test in relation to suspect grounds, and was Lord Mance right about, in asbestosis, about MWRF not applying to the fourth stage of the proportionality analysis. Back it came to the Supreme Court in DA, tab 9, 7 again, 1257, it starts. And the key bits for present purposes, I'm not going to go through it in any great detail because I'm sure the court will reread this and reread it again. The core bits, paragraph 52 to 66 on page 1275 and following in the judgment of Lord Wilson. And you'll see the reliance that is then placed on the judgment of Lord Reed in the first benefit cap case, the famous passage from paragraphs 92 and 93 of that judgment. You see that about a third of the way down page 1276. And you need to read paragraph 57 of the judgment as well, just to complete the sense of that. And then paragraph 59 at the bottom of that page. And he puts it that way deliberately because there had been some doubt expressed, I think, inter alia by him about that, and but he now accepts that in the clearest terms in paragraph 59. You'll note in paragraph 60 in the analysis of Humphreys that he too notes that Baroness Hurl analysed that as being a suspect ground, but nevertheless the normally strict test for justification of the effect of a rule alleged to be discriminatory on grounds of sex gives way. Look at the penultimate line in paragraph 60. But she added, and so on, doesn't escape careful scrutiny. And then I inaccurately summarised an idea floated earlier on. Paragraph 61, he puts it on the basis that the possible mapping of a different path. And then he refers to Lord Mance in Asbestos, Wales. And you'll see the possible other path that Lord Mance had posited there from the final sentence of that paragraph 61 on page 1277.
Sorry, so James, I was wondering whether or not Lady Hale's judgment in DA and DS, whether she was correct in saying that the starting point of James against the United Kingdom, the manifestly without reasonable test did not apply to the fourth question. That is the European Court in James, which was the starting point. Was she correct in that?
I'm not sure she was, no, and I think that's why they departed from it. I think it had been an idea that Mr. Fordham, as he then was very keen on, splitting out the various stages of the analysis and leaving the final one floating free for the court without the benefit of that. And I think that's essentially given the quietus in this judgment ultimately. So I think the short answer to my Lord's question is no. Then just completing the Lord Wilson's analysis. Particularly paragraph 65 And I ask you to focus on that. With the expression of fond but vain hope in the final sentence of 65. Here we are again, one could say, in response to that, but we are here again in response to Strasbourg, perhaps, rather than the domestic court continuing to examine it. But 65 putting the matter to bed, and then 66 again, you know well. So that's Lord Wilson. Then paragraphs 92 to 93, Lord Conworth, Lord Reed, and Lord Hughes. Effectively endorsing the accuracy of the head note in the first benefit caps case, as you see in paragraph 93. And then you'll note in DA, paragraph 96, the significant change, which is noted by the letter E on page 1286. Significant change is that the amount of the cap is embodied in primary legislation rather than regs, as is the benefits to which it applies, including child benefits and child tax credit. Then 98.3, summarising the argument, argued that in the light of the more recent Supreme Court authority, the MWRF criterion applied in SG has been superseded by a broader fair balance test. So back again to the same issue. And then the analysis in relation to that is at 110 through to 118, all of which, it might be thought, deserves reading as the judgment of the of Lords Conworth, Reed, and Hughes. Argument rejected, 110, paragraph 110. Clear expression of the correctness of the MWRF test in the first sentence of 113. The usual citation of Humphreys. The specific reliance on the point that I made earlier about the way in which Baroness Hale had analysed the matter in Humphreys at 114 on page 1291. This is the normally strict test giving way point. Then at 116 on page 1292, put beyond reasonable doubt by the 7-Justice Court in the bedroom tax case, that's M.A. Carmichael, which we've already looked at, and paragraph 32 of Lord Toulson, which was the key one I invited you to read for the principal basis for that approach. And the recording of the acceptance of Baroness Hale in her judgment in that case at 117 by the letter G, she accepts that the decision in MA was reached following a wholesale attack on the MWRF principle. And that we respectfully submit is correct. And then an engagement with Lord Care's dissent in paragraph 118 on page 1293. And of some interest given the domestic and international aspects of margin. Can I just invite you to read the second half of 118? And just to complete the majority judgments, I think I'm right in saying that Lord Hodge, at paragraph 125 on page 1294, agrees with paragraphs 110 to 118, which describes as tallying, correctly describes as tallying with Lord Wilson. So you've got, just to summarise, following repeated challenges and direct challenges and endless consideration, the position in the Supreme Court is, as a single compendious test, it isn't split out for this purpose into different stages of the proportionality analysis. Lord Manson, asbestosis did not fly. The test is squarely MWRF, but that isn't just a point of form. It's MWRF as reflecting base constitutional principles of the kind analysed by Lord Toulson in particular, paragraph 32 of the Carmichael case. And that was firmly rooted in the European Court of Human Rights jurisprudence at the Grand Chamber level, in particular James and Steck, and it was, as it was put, seen as emerging. I'm quoting from Lord Justice Hickinbottom in paragraph 127 of JCWI, which I'll come to in due course, but just for your note, page 2707, paragraph 127 of JCWI, that test, rooted as it was in the jurisprudence of Strasbourg from James onwards, seen as emerging, as you put it, from the margin of appreciation afforded to democratically elected and democratically accountable national authorities in implementing social and economic policy. Steck, Carson, James, a consistent line. So that's the second and third points with the case law in the Supreme Court supporting them. Come back to my 5 submissions. The fourth of them is that an aspect of that area of judgment, or if you will, bearing on the intensity of the court's review, which was how Lord Justice Leggett analysed it at paragraphs 90 to 93 in the Court of Appeal judgment, doesn't matter how you put that, but as an aspect of that area of judgment, as a matter of domestic law, it is important where the decision-making is made. In essence, and again, this is thoroughly well established in our domestic jurisprudence, under our domestic constitutional arrangements, there is, if I can put it this way, a hierarchy of respect, increasing as you head towards or reach the primary legislative summit. The extremely well-known passages in relation to secondary legislation are set out in part in a passage I've already taken you to from the Court of Appeals judgment, paragraph 92. But I do just want to remind you, if nothing else, or to remind some members of the court who weren't the authors of it, of Lord Reed's analysis in the first benefit cap case, the SG case, and the page in the electronic bundle I want is 1400 under 1 tab 12, 1400. Sorry, 1401. And it's really that passage, all of which is a fortiori, we submit, because it's to do with secondary legislation. But can I just invite the court to remind yourselves or read for the first time, possibly, paragraphs 92 to 96 in the judgment of Lord Reed. The short point here is that we're dealing with primary legislation. So all of this is a fortiori. The fifth submission is that there may be questions about precisely how to approach degrees of scrutiny, for example, by Parliament. Of course, primary legislation entails the highest forms and the most rigorous forms of parliamentary scrutiny. And the courts can rely and have consistently relied on the fact that Parliament considered and discussed the very issues that are being attacked as manifestly without reasonable foundation. Or as it was put in the Court of Appeal's judgment, in Lord Justice Legate's judgment at paragraph 93, the Parliament has considered the values and interests relevant to the assessment of proportionality. And the fact that it has done so in this case, and I'll come back to the propriety of looking at this, but the fact that it has done so in this case entails two consequences we submit of note. The first is that there is no reason in this case for shrinking the area of judgment that is accorded to the legislature on the basis that the scrutiny should have been closer because the primary decision maker didn't strike the relevant balances. That's sometimes the way in which it shrunk, at least in relation to secondary legislation, as the misbehaving case very well exemplifies. See Lord Justice Legate's judgment at paragraph 93. But the fact that Parliament has considered these issues is also a powerful constitutional reason for not interfering. That does not involve, I emphasise, in tribute to my learned friend Miss Mountfield's submissions this morning, that does not involve in any shape or form an abdication of the constitutional responsibility of the courts to determine issues of proportionality under the HRA. Of course it doesn't. And no one could sensibly accuse Lord Justice Legate, given the detail that he went into in his judgment, of abdicating that responsibility. But what these principles do is to define in a proper constitutional way the manner in which and the limits on which the courts will operate. That those limits exist is very, very clear and is the base reason constitutionally for the existence of the MWRF doctrine. But the powerful constitutional reason for not interfering can be expressed in a variety of different ways. It can be expressed in the compendious test of manifested without reasonable foundation, or at a more visceral level. It can be expressed as Lord Bingham expressed it in Countryside Alliance, in the passage to which Lord Reid referred, in the passage I've just asked you to read at paragraph 95. However strong the feelings might be, however deep the sense of injustice and grievance, people should not be able to achieve through the courts that which they have tried and failed to persuade Parliament of in the course of the consideration by Parliament of this sort of social or socio-economic issue. To do so would be to subvert, not to promote, the democratic process on which my learned friend Miss Mountfield placed reliance. So the key points to note we respectfully submit at the stage of domestic case law are thus that this MWRF approach, applying to all stages of the analysis, and Lady Hale's analysis of the way that works in relation to even a suspect ground of discrimination, mirrors the European Court of Human Rights approach, but it is in principle a distinct domestic legal analysis. It is founded domestically in faithful compliance with the strictures that Lord Hoffman referred to in Begum and the Supreme Court referred to in the G adoption case, founded on the separation of powers and the respect that is properly to be accorded under the UK Constitution for judgments of a particular kind by the legislative arm. And the second point to note is the more mundane and prosaic one, which is that the principles have been tested again and again with direct and indirect challenges to the MWRF approach, with a direct challenge to that approach as it applies in discrimination, with a direct challenge to whether it applies at all stages of the proportionality analysis. And the Supreme Court has now repeatedly spoken, and it's repeatedly spoken in the same voice, culminating in the DA judgment. And that is the backdrop against which one comes to the JDA case in the chamber in Strasbourg. It's behind tab 14 in bundle 1, starting on page 1469. It post-dated the Court of Appeal judgment, and it post-dated DA in this court. It might be thought that the context is distinguishable in any event. The facts in JD and A involve disability and sex discrimination, and here the difference that actually falls to be justified and its basis, we submit, was correctly and rigorously analysed by Lord Justice Leggett and is on no view suspect. But I will come back to that point if I may. The issue of principle, which my learned friend Mr. Drabble initially skipped and then circled back to, the critical issue of principle is to be found in paragraph 88 of the Chamber's judgment on page 1493. And in essence, they reach two conclusions in that paragraph: that even in the context of socio-economic policy, MWRF was limited to, quote, transitional measures in order to correct an inequality. That's the first conclusion. The second conclusion is that because they were dealing there with disability and or sex discrimination, MWRF effectively fell away and was replaced, rather than the other way around, per Baroness Hale, with a very weighty reasons test to justify the impugned measure. That's 88 and 89. And we make 5 submissions in relation to that, or those conclusions. First, the reasoning in STEC, which if you want it in the raw is in tab 97 at page 4204, the reasoning of the Grand Chamber in STEC is not limited to transitional measures. But true it is that one can characterize the facts of STEC as involving transitional measures, but paragraph 52, which is quoted in the judgment of the Court of Appeal, to take it from that, at paragraph 85. So if you have 85 of the Court of Appeal, you'll see the quotation, the key parts of the quotation from paragraph 52 of the Grand Chamber in STEC. And that is not limited to transitional measures. It's a statement of general principle which sits on a principle basis which plainly is applicable beyond the boundaries of transitional measures. It is based, therefore, not on transitional situations, but rather on national authorities being better placed to make the requisite judgments in relation to economic and social policy. And that, as I've indicated, finds precise echo in our own national constitutional arrangements and hierarchy. So STEC is not correctly analysed in terms of the principle which it lays down as being restricted to transitional measures. But secondly, and still on transitional measures, the consistency even of the Strasbourg jurisprudence is the other way, not purely transitional. Carson, bundle 7, tab 74, page 3387. I don't invite you to turn it up now. You'll recall the facts of it. People weren't getting up ratings to their benefits when they lived abroad in certain countries like South Africa. Not a transitional measure. And yet it cited and applied manifestly without reasonable foundation from STEC and in reliance on STEC. In Strasbourg we're not in the House of Lords, we're in Strasbourg, at paragraph 61 on page 3404. And there are other examples. If you go to B in the United Kingdom, bundle 7, tab 72, page 3355, that was a case about claiming back overpayments in the event of a person with a disability not understanding that they had to report certain events or material changes of circumstances. And the government relied on Carson, paragraph 50 of the decision of the court, and the court cited and relied on MWRF to the same effect, again from STEC. It's exactly the same analysis and exactly the same mantra. See paragraph 56 on page 3369. And again, no need to turn it up because it's exactly the same mantra, exactly the same expression of principle to exactly the same effect. In a case that again didn't involve transitional arrangements, correcting of inequality, Tarco F, bundle 10, tab 98, page 4213, paragraph 58 on page 4230. So those first 2 points relate to the transitional nature and restricting STEC to transitional things. But our third submission is that the chamber in JDA misunderstood in any event how the Grand Chamber in STEC had resolved the balancing between, on the one hand, a serious or suspect status, sex, disability, whatever it may be, and socio-economic balance. It's to be borne in mind in making that submission that STEC had applied MWRF to a situation in which there had been and was direct sex discrimination. That was, as you will recall, the essence of Lady Hale's reasoning in Humphreys at paragraphs 15 to 19. The normally strict test, she said, gives way. And as we also noted, that paragraph, that reasoning of it giving way is picked up and noted by Lord Carnwath in DA at paragraph 114, 1291 electronically, and by Lord Wilson in the same case at paragraph 60, 1277. And it shows that the Grand Chamber resolved the serious suspect status on the one hand and the socio-economic context on the other in paragraph 52 of STEC in favour of all the latitude that the test of MWRF brings in the social security context, at least, when dealing with discrimination. The fourth submission is that the cases that were cited by the Chamber in JDA are, we respectfully submit, a thoroughly unsatisfactory basis for the conclusions reached by the Chamber in JDA. For good measure, they weren't about welfare benefits anyway, but that may be a matter of secondary importance. Can I just pick up the three key ones and just go to the cases that they relied upon? GLOR, G-L-O-R, is the first one. That's a first section decision, bundle 8, tab 79, page 3352. Sorry, 3552, I'm so sorry. 3552 electronically. It's the first section judgment of the 30th of April 2009, if you have that. And it was about the discriminatory imposition of a tax. But you see in this judgment of this section, the citations of STEC at paragraphs 72 and 74 And the reason for drawing attention to those two citations of Steck for those limited propositions that you see set out in the second half of paragraph 72 and the first half of the citation in the brackets of 74 on page 3572 is because you will see that in the citations of Steck in Glaw, they haven't actually cited the key bit of Steck. And maybe that's because they didn't regard this as being within the socio-economic area in the same way as welfare. But if not, and it may be thought that the things are not terribly easily distinguished on that basis, the cases, it was an omission of the key part of the reasoning and conclusion of the Grand Chamber in Steck. And that is because paragraph 52 of Steck is properly analysed by Lady Hale in Humphreys, and it culminates in the MWRF conclusion, resolving the balancing that I've referred to in that way. None of that's referred to in this chamber judgment, still less grappled with. Guberina is 2 tabs further on. I don't know how you can turn tabs electronic, perhaps you can. 3622 behind tab 81. It's going through the key cases relied upon by the chamber in JDA. A chamber judgment again, and again about the discriminatory imposition of a tax, and paragraphs 71 to 73 are perhaps the key ones for present purposes. And again, one struggles, with great respect, to see that the chamber has correctly appreciated what the Grand Chamber in Steck had done. Again, the citation of Steck I think is in footnote 19 on page 3647. For that limited proposition, so the same point I made in relation to Glaw applies. I don't want to be unfair to the chamber. It is right to point out that paragraph 73 at footnote 23, they cite Hämäläinen and Finland, and Hämäläinen and Finland does refer back to paragraph 52 of Steck. But what they take from that is the first sentence in paragraph 73 on page 3647, rather than the totality. And it might be thought that the essence and key to the reasoning in Steck at paragraph 52 is precisely what Lady Hale took from it, which is, what do you do when you've got a suspect ground on the one hand and socio-economic context on the other? And the answer is that they resolve that in favour of MWRF. No mention of MWRF at all in this judgment, still less, again, a grappling with it. Markin, same bundle, tab 87, page 3831. This was a case about parental leave. And that cites Steck at paragraph 125 and 126. So look at footnote 46 on page 3866 and look at footnote 49 on page 3867, both of them citing Steck. And the same point can be made. Not for the core proposition. So our respectful submission is that even on the Strasbourg jurisprudence and taking the authorities that were cited by the Chamber in JDA for their approach about the resolution of that balancing, what do you do, how do you resolve it when there's a suspect category and there's socio-economic context? Those cases are themselves deeply unsatisfactory as a basis for effectively, as we submit, disagreeing with or departing from or not appreciating the reasoning in the Grand Chamber's judgment of paragraph 52 of Steck, which we submit is properly analysed by Lady Hale in Humphreys. That leaves Andrew Javer, and that was a Grand Chamber decision. It's, if you want the judgment in the raw, it's tab 71 of bundle 7, page 3305. And it's fair to say that at least in that case, they did indeed cite, but we would note, approved Steck 52 in all its glory, without too much analysis of paragraph 83. But my submission in relation to Andrew Javer is that it is explained on precisely the basis that it was explained on the facts by Lord Toulson in M.A. Carmichael. You will recall paragraph 37 of Lord Toulson on page 1331. The fifth submission in relation to JDA is that the reasoning of the Chamber, in any event, in principle, is, we respectfully submit, an unsatisfactory species of reasoning. They relied, and no one would quibble with this, in favour of the rejection, on the fact that it is a good thing to prevent disability discrimination and the advancement of gender equality. That is obviously a worthy goal, and no doubt true. But firstly, that does not grapple with the difficult balancing and the resolution of it in paragraph 52 of Steck. And it's also to be noted that in JDA one was fundamentally concerned with indirect discrimination. And one may not need to go too far down the road in this case on this issue, but it wasn't a measure targeted in a directly discriminating way. And there are clear and important distinctions between direct and indirect discrimination, including the fact that justification in relation to indirect discrimination is at the very least likely to focus more, and perhaps exclusively, on the measure itself, as opposed to direct discrimination, where the focus is on the reason for the difference in treatment. See the citations in that respect, including from Lord Reed in SG, that set out in the judgment of the Court of Appeal in our case at paragraph 125. And for good measure on that point, the same point about the difference between indirect and direct discrimination at the justification stage was noted and relied on by the Court of Appeal in the JCWI case at paragraph 148 Roman 1, bundle 5, tab 56, page 2713. And of course, that's an important distinction across the wide range of social security legislation, which will very often have indirectly discriminatory effects and risk cutting across the well-placed decision maker, whether national or within the national constitutional system. That, in essence, was the point made in what we submit are the powerful dissenting judgments or opinions in JDA by judges Pejal and Wojciech. So we submit on the reasoning in JDA, to pull the strands together, firstly, that the reasoning in Steck, properly understood as it was by the House in Humphreys, or the Supreme Court in Humphreys, is clear and compelling and consistent with a proper respect for national systems. It has not been overruled in Strasbourg, or even sub silentio departed from, as sometimes happen with cases allowed to drift quietly into the night. Indeed, it's been repeatedly cited and applied since. the chamber decisions relied upon by the JDA chamber simply do not grapple with that reasoning of the Grand Chamber binding on them, although not strictly or formally, obviously, or the resolution of that balancing in the context of a socio-economic measure of a general kind. And specifically, there was no reference to the key part of STEC, describing the test as MWRF and setting out the reasons why it should be resolved in that way. So the cases relied upon are themselves unsatisfactory, and there's no explanation for why the position should be different here. That leads one into relatively familiar territory, which is headed constructive dialogue. And the test in relation to what a domestic court at the top level might do in this sort of situation is now pretty well thrashed out. The Pinnock, I think it's Lord Newburger and Pinnock, is very well known. We've given it to you in our case at paragraph 42, electronic 147. If you want Pinnock in the raw, it's in bundle 4 tab 46 2214, and the key paragraph is 48 at 2235, Lord Newburger and Pinnock. We gave you in the new or supplemental bundle of authorities that you had overnight. And again, I don't invite you to turn it up now because it'll be very familiar, I'm sure. And you've got the whole case, even though you only need a paragraph or two. But you've got key bits perhaps from Lord Mance in the prisoner voting case in Chester. And the key passage is really in paragraph 27.
So James, could I just
Oh, yes.
just raise one matter with you? Clearly, if the court took the view that the Chamber's reasoning, which incidentally is majority reasoning, there's a powerful dissenting judgment.
There is.
But if the court took the view that the reasoning as to how Strasbourg should itself approach the margin of appreciation was left unclear or was questionable, obviously we could say that in a judgment with a view to inviting clarification or reconsideration of the matter at the Strasbourg level. But your first submission, as I understand it, is that ultimately how Strasbourg treats the margin of appreciation at that level, the international level, is a quite different question from the question as to how British courts should approach applying the Human Rights Act to the acts of British authorities or the British legislature. And that has to be done in a manner which is consistent with our constitutional tradition and our constitutional principles.
My lord, yes, that's exactly how I put it. It's a reflection of the G principle.
Yeah.
Exactly so. And
Thank you
for referring you to, in addition to all the other massive authorities that I'm afraid you've been burdened with, yet more from Chester, is because paragraph 27 is from Lord Mance is quite good, if I'm allowed to put it that way with respect, on dialogue being appropriate, even if we're in the territory of dialogue, partly of the debate we've just been having, when you're dealing with a chamber decision, as compared to, and we all recall it, the position as it was in Chester, where the UK government had tried repeatedly in front of the Grand Chamber to get them to reverse Hurst and the United Kingdom, including a rather desultory and ill-fated expedition in an Italian case called, I can't remember what, Sacolo, I think. But in any event, you had two Grand Chamber decisions. So if one reads Lord Sumption's judgment, it's slightly like raging against the dying of the light, but with the court slightly unconvinced by the logic of the Strasbourg reasoning, but nevertheless. bound by, as it were, the fact that further dialogue would not be terribly fruitful. By contrast, see paragraph 27, and we would say a fortiori, if you've got, as you have in our case, serious doubts about the consistency of that reasoning with the Strasbourg jurisprudence in its own right and internally, and powerful dissents. This is not clear and consistent jurisprudence. It is the short point. True it is, as you have been reminded, that the Grand Chamber refused to take it, but again, you will know how that process operates. And what happens is that the case goes amongst with a number of other cases, no doubt, as they did on this occasion, to a committee which provides no reasons and just says yes, yes, no, no, yes, yes. So we've no idea on what basis, and so one can't, as it were, infer anything against me from that beyond the fact that someone has decided on a wet and windy day in January that they're not going to take it to the Grand Chamber. But if principal bases for doing so exist, we respectfully submit that that should be your guide. So we do say that constructive dialogue ain't over, which is a good thing. I wanted to refer you to two other cases, if I may, without wishing to trespass on your grandness, because they're both Court of Appeal cases. And the first one is the JCWI case, which I've mentioned on a couple of occasions. Can I just invite you to go to page 2706 electronically, bundle 5, tab 56 in the old money. And the only reason I'm going to these two cases is because this is the highest that the question of how, if at all, do you slot, as it were, JDA, assuming you take it at face value and assuming you take it as good, and I've made my submissions as to why you shouldn't take either of those things, but assume you take it as good, how, if at all, does it slot in to the domestic case law and the test of MWRF and so on? And I don't want to go through it in any detail, particularly given the timing we're on, but can I refer you for at least a thoughtful and interesting analysis, if I can say so with respect, in Lord Justice Higginbotham's judgment, paragraphs 124 on page 2706, all the way through to 148, in which he thoroughly agrees inter alia with Lord Justice Leggett in our case at paragraph 87, see his 138 on page 2710, and ultimately concludes, as you see at paragraph 148, Roman 4 on page 2714, ultimately concludes, as you see there, that effectively Humphreys was authority for that proposition. And still in the same physical bundle, Court of Appeal again, this time the Master of the Rolls, Lord Justice Underhill and Lady Justice Rose, tab 54, page 2631 is the relevant bit, and the paragraphs of particular relevance, it might be thought, are paragraphs 88 on page 2631 to 92 or 93 perhaps. And it may be worth, can I just invite you to quickly skim an eye down those? You obviously don't need to read the chunk from paragraph 87 of Lord Justice Leggett, which they liked equally. My lord, I was wondering if that might be a convenient moment for 5 minutes. I think you might have been mute, my lord, sorry. It hadn't quite unmuted you. No, you've muted yourself again.
Fine. Thank you, Sir James. We'll get there in the end. We'll adjourn for 5 minutes. We're now ready to resume the hearing. Sir James.
My lady, thank you. I was going to turn, if I may, to the UNCRC and Article 9 of the Bill of Rights issues, if any. And the some of the contextual points of this are pretty obvious. This is an international instrument. It is not part of domestic law. If it comes into domestic law at all, it must come in through the gateway marked Strasbourg analysis. And our submission is that there is very considerable force indeed to the thoughtful and very detailed analysis of this issue in Lord Justice Legate's judgment at paragraph 111 and following. And I should note, just by way of chronology, that the Supreme Court in DA gave judgment on the 19th of May 2019, and the Court of Appeal in our case gave judgment about a month earlier on the 16th of April 2019. And the fault is, I'm sure, shared between all of us, but no doubt principally ours, but it appears, and I've asked for it to be checked overnight, and it appears, and if Mr. Drabble knows differently, he must say so, that the reasoning of Lord Justice Legate on these issues was not before the Supreme Court in DA. There's certainly no analysis of the detail of that thinking in DA.
Yep.
And it is therefore of some interest to see how Lord Justice Legate approached the issues on the vexed question of how the UNCRC applies in a case like this. So if you go back to the Court of Appeal judgment, if you would, to paragraph 111, he recognises that the Supreme Court is about to get onto it, and that's in the DA case, although without the benefit, as I say, of his reasoning. I think he waited for a considerable time to see if the DA judgment came out, and then when it didn't, eventually it had obviously been written, so it was promulgated anyway the month before. But 112, first of all, if I can just invite you to cast an eye over that first five or six lines, first sentence of that. That, I think, is a reflection of what my Lord Sales was referring to as direct passporting of the UNCRC. So you just take UNCRC, you effectively say, well, there it is, it's now part of the Article 14 analysis. If someone can show that you breached it either substantively or procedurally, it necessarily follows that Article 14 must be breached as well. But Lord Justice Legate was unkeen on that idea for the reasons that he gives in the remainder of 112, recognizing in particular the distinction between, or potential distinction between interpretation and justification, demure having been about interpretation of convention articles. Then 113 you see saying, well, it may not be quite as tight as pure interpretation. It might form part of something of relevance to the justification analysis as opposed to a pure textual interpretation relevance. 113. 114. whether it's relevant, and if so, how, depends on the nature of the discrimination and the reasons relied upon to justify it, is really the punchline of 114. And you'll see the sort of thing that he has in mind from 115, first sentence. Of particular interest, it might be thought, is 116 and his fourth general point, which goes to the procedural part of the UNCRC, if any. And in particular, tying that back to the domestic analysis of proportionality, which is the other feature of misbehaving, which is well known, and Begum and Denby High School, which is that you judge the proportionality of primary legislation by reference to its effects, rather than whether a correct procedure was or wasn't followed before you get to that outcome. And he notes the two forms of discrimination in 117. So you've got, effectively, in this case, indirect discrimination against women, because it has more significant impacts on women than men. It might be thought that it's now been established clearly that in relation to that sort of discrimination, see the first bedroom tax case, the UNCRC has no part to play, because that's discrimination on the grounds of sex. And second, the correct analysis here is to treat larger families which include more than 2 children less favourably than the smaller families which include only 1 or 2. And as to that analysis, as to that second group, the Court of Appeal's analysis, C120, of their judgment was that the 2-child limit doesn't discriminate against children as a group. Come back to that a bit later. That's 120 by reference back to judgment, paragraphs 81 in particular. The mere fact that the group disadvantaged includes children doesn't necessarily make the UNCRC relevant to justification. They're not being treated less favourably on the ground that they're children, but because of the number of children in the household. That's paragraph 120. And Lord Justice Leggett then concluded that 3.1 might be relevant, if at all, given the nature of the rationale relied on to justify treating them, those households differently. But so you've got, in terms of the overall reliance on the UNCRC, at least some very serious issues of principle at the beginning of the analysis. And we respectfully agree that Lord Wilson in the DA case, particularly paragraphs 71 and 78, which you've already looked at, was indeed very cautious, and also was intent correctly on linking back any such use to the ECHR. So even if you reach the stage where you conclude that at the least in DA, the court were treating the UNCRC as potentially relevant even to issues of justification, there is still a question as to the degree and nature of that relevance in the context of Article 14 and the analysis under Article 14. That particularly bears on the procedural aspect, recognising that our domestic principles have allowed for a failure to consider to play into that analysis as a mechanism for shrinking the margin that would otherwise be affordable to the primary decision maker. Non sequitur that you then suddenly import from a non-binding international instrument, some form of harder edged passporting type analysis that says if you breach the procedure, it must follow that you're in breach of the article. That simply doesn't follow, is not the reasoning of any of our courts. And as Mr. Drabble entirely fairly accepted, has never been the reasoning of the European Court of Human Rights in Strasbourg. Just to try and consider the UNCRC in its two aspects, the two aspects that have become relevant through the cases, the procedural aspect first and then the substantive. We can take the substantive much more shortly, but focus first of all on the procedural side. The starting point of that is, again, the trite one and the uncontroversial one, it appears. The UNCRC does not in terms impose any procedural obligation on a state. That was simply and at most a committee view, which, as Lord Reed again correctly pointed out, and has been pointed out by courts in the past, was not even binding on the international plane, simply a view of a committee. Procedurally here, this was a parliamentary decision with Parliament as the primary decision maker, operating as it does in making primary legislation. A key question, it might be thought, is thus, even if you're into this as relevant, whether Parliament considered the interests of children before deciding that it was appropriate to enact the measure under challenge. And I leave that deliberately broad because there is a question in which the Court of Appeal were interested as to whether or not that means children as a group. And again, it's back to my point about defining levels of generality. Does that mean children across the board? Or does that mean the interests of the children who are self-evidently adversely affected if their household's overall income reduces in this way? My submission would be that one can see the force for analysing it in both ways. Of saying, well, you can't exclude because it's a general measure, looking at children in the generality, and that is an appropriate focus for inquiry and consideration in principle. But likewise, it's maybe appropriate and sensible also to look at specifically at the interests of those who are affected. That they were affected, there's no doubt. It might be thought to be tolerably obvious for the reasons that I've given. My short submission in relation to your entitlement to look at what Parliament had before it is that you are just as entitled as the Supreme Court was in DA to have regard to all the strands of information that were before Parliament when it was enacting this legislation. It might be thought to some extent to be self-evident, to go back to the distinction I've just been drawing, at least in terms of the immediate receipt of benefit, that the sort of limit introduced by this primary legislation viewed in isolation was self-evidently not, as it were, in the best interest because it took money away from households in which the 3/4 and following children sat. But we are here dealing with judgments of a broad legislative kind, which the Court of Appeal ultimately and correctly concluded could and should only be made by Parliament. The key procedural finding, it might be thought, of the Court of Appeal is contained in paragraph 158 of their judgment, and it was that, and I quote, the interests of the children affected were considered by the legislature as part of that process of scrutiny. And that is self-evidently true. Those interests were carefully considered by Parliament, which then advisedly enacted the primary legislation. Indeed, many of the points that were being made were the very points now being raised as perceived unfairness in the new system, given at paragraph 154 of the judgment. The position in relation to, if I can do this de Bene essay for the moment, and I'll come to Article 9 in a second, but the position in relation to the key points on that set of debates and the materials that were before Parliament. There's a fuller exposition of that in the judgment at first instance of Mr. Justice Ouseley between paragraphs 40 and 50 of his judgment, setting out those matters under the heading of the background of the policy and the debates. And can I also refer you to paragraph 209 to 211 of that judgment?
I was wondering, Sir James, whether I could bring you to the electronic page 3248, which is Lord Nichols of Birkenhead,
Yes.
setting out, and in particular, paragraph 62, which is the function of this court in arriving at a proportionality evaluation.
Yes.
And he says, if you look just above letter F of paragraph 62, the court must decide whether the means employed by the statute to achieve the policy objective is appropriate and not disproportionate in its effect. This involves a value judgment by the court made by reference to the circumstances prevailing when the issue has to be decided. It is the current effect and the impact of the legislation which matter, not the position when the legislation was enacted or came into force. So what evidence do we have, or what evidence has been submitted on behalf of the Secretary of State as to the current effect of this legislation on the cohort of children who are affected by it?
Well, my lord, I think one needs to be a bit careful with that. Primary legislation does not drift in and out of incompatibility by reference to changing circumstances on the application of that legislation.
And
So,
the
legislation
is incorrect in that assessment. Then.
You judge the legislation by reference to its effect,
Okay.
The effect of the legislation rather than anything else.
Okay.
But as I say, my submission is that you don't drift. If primary legislation doesn't drift in and out.
But
There may,
look at the effect of legislation as envisaged then at the time that it was passed. What was the anticipated effect on how many children and to what effect?
well, my lord, the answer to that is that we know, I'm going to come back to this tomorrow probably now, but we know that the cost savings that were estimated to be made were very significant. I've mentioned the figure of 2 billion. So we know that the impact of this change was to be and was intended to be and was well understood by Parliament to be significant. It is equally clear and obvious that if you are removing money from households after the transitional provisions have unwound, as it were, and you're removing finances from households with 3, 4 and following children, that the potential for that removal could be serious. Those were points that were all made and were clearly made by CPAG, by members in the debate in the Commons, by members of the debate in the Lords. It was the foundation for the suggestion that the two-child rule should come out of the legislation in the Lords, as you saw from the table that was submitted. And you don't need, in my submission, to comply with any sort of procedural duty, still less the justification on proportionality grounds of legislation. You don't need to descend into those sorts of detailed analyses. It's just not necessary, because the ultimate judgment is a broad legislative one. Is this, by reference to the acknowledged impacts as Parliament saw them to be in the light of the debates and all the things that have been put before it, is this a fair and appropriate piece of legislation to enact? It's simply unnecessary to descend into the level of detail which appears to be the premise for my Lord's question, is my submission. My Lord Sales has his hand up, but maybe
Thank you.
He has a follow-up.
Yes, I was just wondering whether you're quite right on paragraph 62 in the Wilson case. I would have thought that the point that Lord Nichols is making is that sometimes you can have legislation which is proportionate when passed, and then there is a change of circumstances, And at the time it comes to be applied, applying it in the particular facts of a case, it would be disproportionate. And that in such a case, you're looking at its application at the time it falls to be applied. But I wonder whether actually the last sentence in brackets there is of significance for us, because the question is whether there has been a significant change in circumstances which justifies one in looking at the matter sort of afresh and de novo, rather than looking at it through the eyes of the legislature. Whereas I would have thought in our case that there hasn't been a significant change of circumstances as such, which is relied on by the appellant to suggest that things have changed in a significant way since Parliament legislated.
Yeah, my lord, I see the force of that, and I suspect the only thing I would add perhaps to that thought is that it may be as well that one has to think about the difference between individual cases as applied under the legislation as it goes forward. You get quickly into all those Christian Institute type issues as to how many cases before the legislation itself becomes problematic. And normally the answer that the Supreme Court has given, I'm thinking in particular of Christian Institute, to that set of issues, it's got to be quite a number. The legislation itself has to be incapable of being operated. I'm sure I got the word wrong, but I think that was the sense of, I think it was Lord Reed's judgment in Christian Institute. But so individual cases may well be a variant on the currency issue that Lord Wilson is referring to. My lady, I'm sorry, you've had your hand up far too long.
Not at all. Sorry to detain you on the facts for a little bit longer, but I note, I want to follow up Lord Stephen's question. I note that when you were telling us what had been considered in Parliament, it was what MPs said, what the Child Poverty Action Group said, etc. Am I right in thinking the government hadn't identified this particular adverse impact in anything that it placed before Parliament, or in the impact assessment?
My lady, I think that is a fair point. Is my answer to that. I mean, there is reference to the interests of children in the impact assessment. There is reference in the memo to the JCHR to that which you've seen already today, and that's referred to in Mr. Higlett's statement at paragraph 64. But I think it is fair to say that there is no government document that says we now are setting out that we anticipate that X number of children will be in the 3-4 category, or maybe in the 3-4 category in the future, and we think it may or may not be problematic, or particularly problematic for some of them because.
Well, I don't see in the impact assessment anything about the adverse effect on children.
My lady, you're right, and in the JCHR memo, it's a similar effect. There's something more in there, but I don't have a document that says it's the analysis that was done which demonstrates that. But
Thank you.
I do say, as you know, that when you're dealing particularly with Parliament, perhaps even when you're dealing with secondary legislation, because there may be other cases wending their weary way to this court involving something similar in relation to secondary legislation, I do say it makes, particularly in relation to primary legislation, all the difference what was before Parliament, because ultimately you're dealing with them as the decision maker. So I suspect I can probably accept both directly the question you ask and perhaps a large part or a large chunk of the premise of Lord Stephen's question. My answer is different.
Got it. Thank you.
We do have in the judgment of Mr. Justice Ousley the information about estimated numbers of children and estimated numbers of families who would be affected. That was before Parliament in briefings, in fact in the briefing paper prepared by the House of Commons summarising what had been stated by the Child Poverty Action Group and the Institute for Fiscal Studies. It's on page 270.
Yes, my lord, I don't want to take, I think one needs to be a little careful with that. It's a point against myself rather than for me. But I think in fairness, the reference to CPAG in the in the Commons Library briefing paper is reference to CPAG's documentation and submissions post the passage of the primary and make
yes.
context of the regulations.
Yes. I see. Right, thank you.
Does that make sense?
Yes, it does.
I mean, I would love to be able to say, rely on all of that as something prior to the primary, but sadly, if any CPAG had got in there sooner, my case would be a great deal easier.
Yes.
Right to point that out. You can't take that as having been there before the primary.
Yes.
Subject, of course, to my Lord Stevens being right about his construction of paragraph 62 of Lord Wilson, in which case I rely on it in spades.
I see. So the table that we have summarising the material before Parliament, is that pre-enactment material? Yes, I think it is all pre-enactment material.
It's all pre-enactment material, and I'm hoping it doesn't contain the CPAG stuff. It may contain something from CPAG by reference to the Alison Garnham witness statement on the second page, but it's designed to be pre-primary.
Yes.
Whereas the Commons Library briefing paper with that helpful bit saying other responses and then the references to what CPAG was saying, I think is post, but primary regulations which contain the exception.
Yes, although clearly the CPAG had submitted material before the bill was enacted.
Yes.
That's referred to in the
statement. Yeah. I mean, I just don't. I'm not sure we know precisely when they put things in and who they were briefing, even for the purpose of teeing up debates and questions and so on.
Yeah. Thank you.
You should note that. So there's a bit of caution about that, however tempting it may have first appeared.
Yeah. Yeah.
Lord Stevens, sorry.
I do apologize. I just wanted to get the actual financial figure correct in my mind. You say it's a saving of 2 billion. Over what period of time? Is that annual, or is it over the lifetime of the Parliament, or what?
Not sure. May I check that? I'm sure it's somewhere in. Mr. Higlitz, can I check that and get back to you? I'm not sure. I'm pretty sure.
And that literally is 2 billion that would otherwise have gone to children.
I think it's 2 billion referable to this change, if you want to characterize it in that way, yes.
Yeah, okay. But I'd be grateful to know whether that's
time scale.
Or whether it's over the lifetime.
Yes, understood. I'll check that overnight. Yes, so you have the new clip. I think I've probably done enough on the new clip. We deliberately haven't given you, unless you want it, we can easily furnish it. Where it's in your bundles in the electronic, it's EF. And DHX, I think, refers to and DH refers to to Mr. Higlett. But if you wanted the particular pages that are referred to there, I'm sure they can be provided electronically, but that was all material that was before at least the first instance court.
Yeah.
So we've tried to restrict that to pre-primary and to the evidence that was at least before Mr. Justice Ouseley. So we submit, therefore, in relation to the procedural side of things, that there is a pretty big question which Lord Justice Leggett grapples with, we respectfully submit very convincingly, in relation to the procedural side about whether the UNCRC and the General Committee are obligation, if that's the right way of looking at it.
So James, I'm so sorry, just before we drift away from the table.
Yes.
There are procedures within Parliament for documents to be laid in the library of the House and so on. The idea being that that's a way of communicating information to MPs generally.
Yeah.
I mean, this table doesn't seem to deal with that sort of information, which I myself had rather understood Lord Reid to be asking about when he asked for this information. This just seems to have been someone who's gone through the evidence, picking bits out.
Yeah.
But there must be a formal record, I would have thought, of what actually was placed before Parliament.
Well,
Could that be looked at overnight as well?
I'll double check that again. I mean, we have got a library briefing paper, but it was produced, as it were, after the primary. I don't know whether it's traditional in terms of parliamentary procedure to lay that sort of material in advance of primary legislation, as compared to there being, you know, white papers and other things that set out the policy. I'm not sure, but I'll check.
Well, if that could be checked, I think that might be helpful at any rate. Thank you.
Of course, I'll certainly see. Is there anything else I can help with on the table at this stage? No. So there's then a question, which is whether or not one can look at any of this. And there's an Article 9 question floating around, which is obviously deserves serious consideration because it's an important provision. And it may be thought that may not provide an answer in principle, but it's at least a pretty decent forensic answer, which is that the Supreme Court in DA looked at precisely this sort of material for precisely this purpose, perhaps a fortiori here, where one's dealing with primary legislation. Perhaps that was primary as well, but anyway, they looked at exactly this sort of material. It wasn't just material emanating from the government. They looked at the debates. They looked at the fact that someone had produced an amendment for the purpose of taking out the offending provision or altering the cap. Same here, we've got someone producing an amendment to take out the two-child rule. They look at questions having been asked that raise the issue of those having been affected. And it's perhaps unsurprising, given that one's considering a parliamentary process, that should at least be done. The question is whether one can have regard for this purpose to that fact. And to some extent, the starting point of the analysis under Article 9, whether that's constitutionally objectionable, is that we are here dealing with a particular premise, and the particular premise is that it is actually relevant for the purpose of the proportionality analysis under Article 14 to look and see, let's assume, much of the argument I've just been making, but it is actually relevant to look and see whether the particular interest of those who were affected was in fact, or were in fact raised and considered by the primary decision maker. Well, if that is an integral part of the proportionality analysis, it would be pretty bizarre, it might be thought, if you ended up in a position where one couldn't rely upon the fact of those interests having been raised before the primary decision maker took their decision to legislate. That would be a deeply unsatisfactory position. And it can't depend, at least in the context of primary legislation, it can't just depend upon the source of the information. Parliament takes just as much account of what people say in debates and amendments that are put forward and all of that. They take just as much account to that as they do to information from other sources. More fundamentally, in coming to the nature of the authorities and the principles that govern Article 9 of the Bill of Rights, those will probably be, I'm sure, familiar to many of you, if not all of you. And it is at least worth noting that if you look at this sort of material for this sort of purpose, as the Supreme Court did in DA, what was said in Parliament, to take that as an example, it is not being challenged as untrue or ill-motivated. What was said is uncontroversial as a historic fact. That it was raised, and that it was raised in that form, is not controversial. You're not making value judgments about the wisdom or otherwise of a particular intervention, or evaluating whether a minister dismissing an objection or dismissing an amendment in debate was good, bad, or indifferent. You're simply looking to see that the point was raised. So there's no question of being drawn into either the untrue or ill-motivated paradigm territory covered by Article 9, nor is there any question of the parties or the court being drawn into the sort of OGC, Mr. Justice Stanley Burnton, as he then was, the Office of Government Commerce case, drawn into the impermissible territory of, as it were, the court having to decide whether an opinion stated in Parliament was right or wrong. And very often, as you will recall, there was claimants would in particular try and rely upon a select committee saying this part of the government's policy is utterly indefensible and morally reprehensible. And the difficulty with that is that if a claimant seeks to rely upon it, you then immediately have to get sucked into the debate and the court has to rule and all the rest of it. So the court have set their face on Article 9 grounds against that sort of exercise. Again, not us. The purpose of the exercise is not to assess the quality of the reasons advanced in support of the legislation, or the wisdom or otherwise of an objection to legislation by raising particular interests that would be affected adversely, but to see that it was done, simply to show that matters were raised and debated as part of ordinary legislative debate and considered and responded to by government. And so all that remains is the making of as it were, a consequential legal submission. If you take what was put before Parliament and you make, which we respectfully submit you have to in order to avoid precisely getting sucked into that sort of debate, what I think Lord Sales described as the beneficent inference that says they took it into account and thought about it properly if it was raised before them, then there is no particular difficulty, we submit.
This point, Sir James, was emphasised by Lord Carnwath in DA in the last paragraph of his judgment, which was 123. It's on page 1294, where he deprecates the fact that the court had been faced with a great deal of factual and statistical evidence, and said that at times it seemed as though the court were being invited to take on the task of a parliamentary select committee undertaking a review of the policy and factual basis of the legislation, and said that's not our role.
Yes, and my lord, I suspect that very much a similar line of thinking is to be found in both your judgment and the Lord Newberger, Lord Mant's judgment in HS2.
Yes.
I mean, that's really the distinction that was being relied upon there. I think, to summarize, no doubt in grotesquely oversimplifying form, what was being said in the HS2 case, it was here you've got a hybrid form of parliamentary procedure, and in relation to that, it is possible for information to be provided that will satisfy the EIA obligation under EU law. We don't have to get, said I think both you and Lord Newberger and Lord Mance, into evaluating whether that's good, bad or indifferent. So it is the same thought that permeates, but it highlights that distinction. As I say, if the premise is that you have, through Article 3.1 of the UNCRC, or more generally through Article 14, in more or less a hard-edged form, a requirement to demonstrate that the particular interests of those who are affected by the difference of treatment that is alleged were taken into account or thought about. If that is the procedural requirement, you can perfectly happily look at that and say, well, there we are. It was considered. It was specifically what the amendment was about, for example, without having to get into evaluating all of those sorts of things. And as I said earlier, it would be very, very strange if that was an inherent part of the principle and objective for the court to undertake. But you couldn't look at that sort of material. It might be thought that the line is also reflected if you're in DA. I think it may be, to pick up my Lord Reed's thought, but that is also the line that is being drawn, if not expressly stated, in Lord Wilson at paragraph 87, 1283. Whilst you read that, may I just close the door? You'll see in particular at the bottom of page 1283, this court must impose on itself the discipline not from its limited perspective to address whether the government's evaluation of its impact was questionable, nor whether the assessment of the best interests of young children was unbalanced in favour of perceived long-term. So you don't look at it for the merits, for the evaluative purpose. You look at it for the fact of it having been taken into account. And that is a clear and consistent and proper distinction that reflects the strictures that are implied in Article 9 of not impeaching or questioning proceedings in Parliament. My learned friend Mr. Drabble's purported answer to all this is, well, you can solve all this by demanding a parliamentary resolution. But that, I respectfully submit, involves illustrating the difficulties rather than solving them. And it isn't how Parliament realistically works. It's entirely unrealistic to suppose that that would be so, precisely because different people may vote for primary legislation for a whole heap of different reasons. There can be no requirement imported. I mean, it's an enormous stretch if one thinks about it. The balance goes Article 14, informed by something hard-edged brought in through Article 3 of the UNCRC, even though it's not a part of domestic law, by a process of, quote, interpretation through Demir and Turkey, to a position in which Parliament has to explain precisely how it did the thing when it was passing primary legislation. You don't need to find a settled parliamentary view on the best interests, precisely because that would involve an evaluation. And ultimately, what Parliament does is to legislate. So the outcome of the parliamentary consideration is the legislation in the form in which it is enacted by Parliament, after all those interests have been taken into account. You don't need not merely would be unnecessary and unrealistic, but it would be wholly inappropriate for Parliament to be doing that sort of thing, because the thing that the expression of its view, back to the other principle relied upon in HS2, the expression of its view is the primary legislation. And it's on the basis of the primary legislation that incompatibility is judged ultimately. So that's what we say about the procedural side of the UNCRC. Substantively, in relation to the UNCRC, if you get there, again, there's something of a principal difficulty at the outset of relying on substantive rights to the extent that they exist in the UNCRC or indeed the other international instruments that are referred to by my learned friend Miss Mountfield. And that is because, as has been said on a number of different occasions, and I think was repeated by Lord Reid in argument this morning, the ECHR is not concerned with social and economic rights. And I think Mr. Drabble accepted that Article 26, to take that as an example from the UNCRC, had never been referred to or relied on in any Strasbourg case at all. You're back to the extent to which those sorts of rights truly inform the analysis under Article 14. But in any event, we submit, there is no entitlement under the UNCRC of the specific kind that would need to be demonstrated for the substantive parts of the UNCRC to be interesting to the Article 14 or even the Article 8 analysis. There's no entitlement to a national system of social security that flexes, to take the ghastly word, that flexes to accommodate any number of children. National law and different systems of national law, no doubt infinitely variable as they are unsurprisingly built in to the UNCRC structure. And it is to be noted by way of illustration that in our case, lots of benefits and lots of different strands feed into the amount of money that a household receives, of which this is a part, but only. Some flex, some don't flex, some flex to a degree and then stop, as this one post change, and so on. And to some extent, one's dealing with something not terribly dissimilar to the cap itself. So if one sees the themes, as it were, if you go back to the UNCRC itself behind tab 3, you will see that not merely are national, the potentially infinite variability of national systems of supporting children, providing socioeconomic support for children and so on, not merely are those national systems taken into account, but so are the particular national available resources. So look, for example, at Article 4, page 1095. Second sentence of Article 4. And look, for example, if you want another one in relation to one of the articles referred to by my learned friend Miss Matfield this morning, look at Article 27 on page 1101. But look at the lead-in wording to Article 27.3. So you've got a system internationally which, entirely unsurprisingly, does not confer absolute entitlements. It confers entitlements that are conditioned by decisions of the local national legislature, which are properly to be taken into account, and which the member states have freedom to decide upon, depending upon, in particular, their resources. And of course, once you bring in their resources, you necessarily bring in the balance of resources, how the state benefits are funded, fairness to taxpayers as compared to fairness to those on benefits. All of that comes in. So you've got a system which in principle allows for those matters to be taken into account as relevant and perhaps critical, but not a system of absolute rights. And in any event, there's nothing in the UNCRC substantively to suggest that it is necessary, particularly having regard to those features, to provide as a strand of your overall package that goes to a household, infinite flex for an infinite number of children for those who are on benefits. That's not an unsympathetic view, it's simply a realistic view of how nation states around the world are constrained by resources and have to make their own individual national decisions with all the balances that are entailed, back to our constitution, how this decision making is done, all of the features which are necessary to be taken into account in striking those balances. So we submit that there is nothing of any real interest to be derived for the purpose of the present analysis, both in principle and on the facts, either from the procedural side or from the substantive side of the articles of the UNCRC. I was about to say the articles pace, the idea that the procedural side is not actually covered in any of the articles in the first place. So we make the submissions we do on that, and then on Article 9 and the acceptability of receiving, for the purpose of this analysis, all the materials which are currently relied upon, were relied on in DA, were relied on by the Court of Appeal, and were relied on by Mr. Justice Ouseley in this case. And there's nothing inconsistent, we submit, with the analysis of Lord Wilson in Wilson and First County Trust in doing that. Indeed, it might be thought that it's positively consistent with Lord Wilson's approach to rely upon it for that limited purpose. It doesn't violate the evaluative principle. You're not therefore questioning proceedings in Parliament. And you are, as it were, allowing Article 9 of the Bill of Rights to sit in a coherent manner as part of the legislative scheme with the Human Rights Act. And if the Human Rights Act imposes this sort of duty, or this as a relevant factor in whatever loose form as part of the proportionality analysis, you must be entitled to take into account the fact without straying over that evaluative line. My lady, my lords, I see the time, and I've got to a natural breaking point, and I'm very, very confident that I will be through so as to allow my learned friend, Mr. Drabble, what we'd describe when we were talking during the short adjournment as a proper reply. We're not entirely sure, as the subject of detailed negotiations yet to come, precisely what that means in terms of time. But I'm pretty confident that I can be done so as to allow him a proper time, if you'll leave yourselves to our good judgment on that, even if we were to start at 10:30. But I'm in your hands, and in many advocates said that and been proved wrong. And if the questioning gets lively tomorrow morning, timing may go with it. I see Lord Stevens grinning at that at least.
Well, I don't think so far there's been anything that would have taken Mr. Drabble by surprise, at any rate.
No.
Can I ask Mr. Drabble if he shares Sir James's optimism that if we started at 10:30, we would be able to finish by 12:30?
I mean, that does demand a reasonable guarantee. This is the negotiations that we've just been talking about. A reasonable guarantee by Sir James that he will be finished by, say, I think we have to finish at 12:30, don't we?
Yes, we do. Yes. Well, if you're in doubt, the prudent thing for us to do is to sit at 10, and if we finish early, then so much the better.
Exactly. So I think I feel most comfortable with that. I mean,
yes, I entirely understand.
That won't extend my reply unless I've got something to say. But
no.
Well, I think I will feel more comfortable given the fact we are finishing at 12:30.
Yes, entirely understand.
Yeah.
Very well then. Well, in that case, we'll adjourn now for the day and resume at 10 o'clock tomorrow morning. Thank you all very much.